Dear students, viewers, and the subscribers, welcome to the IAS Mentor. This would be lecture number 63 in the series Indian Polity. The topic that you are going to discuss today is the state emergency or the president rule. In the previous lectures, we already tried to understand as to what is national emergency, the consequences of national emergency. We also understood the financial emergency and the consequences of the financial emergency. So this would probably the last lecture for the topic emergency, where we'll deal with what is state emergency or the president rule, and of course the consequences of the state emergency or the president rule, very important. And along with the provisions in the constitution related to the state emergency or the president rule, we'll also touch upon important case laws and the interpretation of the courts with regard to the emergency provisions. To be very specific, the president rule, because there has been lot of issues if you see the constitutional history of India in relation to the exercise of this particular power, that is Article 356 in the constitution. There were allegations that this particular power under Article 356 has been abused by the central government to impose president rule in various states from the beginning of the constitution, not any specific government but in general. And to that extent, the Supreme Court of India has intervened and they have given certain guidelines as to what is the appropriate use of power under Article 356, and which has specifically given guidelines in a case which is called as the SR Bommai case. We'll try to understand about that particular case also. So overall, I would say it's a very important topic in general for your preparation. So first we'll have to understand about the provisions of Article 356. So we'll try to understand what exactly Article 356 of the Constitution says, and further we'll try to understand as to what is the procedure to impose the state emergency or the president rule, and of course the case laws, the consequences, everything will be understood as we'll proceed further. So first and foremost thing, to understand as to what is president rule, we'll have to understand as to what is the reason for this Article 356. So normally if you say in a federal political system, India is a federal political system, although there is criticism that it is quasi-federal, but nobody can deny the fact that there exists what is called as division of powers between the center and the states. There is no doubt in that particular regard. So normally if you see the way the constitution has been designed, who is supposed to govern the state is the state administration. It is a state government. So to that extent the power has been given to the state government. So what do I mean by state government? The state executives. There is a chief minister and the council of ministers, and then there's a constitutional head for each and every state who is none other than the governor of that particular state. So basically each and every state is administered by the state government. So that is what happens during the normal time, but we are not talking about the normal time. We are trying to understand a provision in the constitution which is called a state emergency or the president rule. So normally who will administer the state government? The state executives. But however, when there is a declaration or when there is a proclamation of state emergency, or when the state emergency is imposed in a particular state, then the state administration is not carried out by the state government, because under such a circumstance the state administration is dissolved, or there will be no chief minister and the council of ministers, and the entire administration of that particular state is taken up by the president of India. So who will take up the administration of that particular state? The president of India. Temporarily, for time being, it will be taken up by the president. But on behalf of the president, somebody else will carry out the administration. Maybe the governor might carry out the administration, but it is generally what is called as a president rule. That means ultimately the head of the state during the time when the state emergency imposed is what is called as a president. The president may confer this power to the governor or certain other authorities. So normally the governor would continue to be there. So the governor would carry out the administration, but the administrative head would be the president during what is called as a president rule. That is why it is called as the president rule or the state emergency. So this is the basic understanding you should have. But why this provision of Article 356 was part of the constitution? Why there was a provision for president rule? The reason that was discussed in the Constituent Assembly is during normal time, the state administration would be carried out by the state government, which is headed by the chief minister and the council of ministers. When everything is carried out in accordance with the provisions of the constitution, no problem. But the Constituent Assembly was thinking, what if there is a constitutional breakdown in a particular state? So what does this mean by the constitutional breakdown? So constitutional breakdown means, to put it in a very simple way, you can understand that the administration of the state is not carried out in accordance with the provisions of the Constitution. If the administration is not carried out in accordance with the provisions of the Constitution, then we can say that there is a constitutional breakdown in that particular state. Say for example, I'll just give an example to understand as to what is this constitutional breakdown, because the word constitutional breakdown is not defined in the Constitution. So we'll have to understand as to what is this constitutional breakdown. What is this constitutional breakdown? So constitutional breakdown means, say for example, one of the provision in the Constitution is that any government which is there in a particular state, they shall have a majority, because India is a parliamentary democracy, and in the parliamentary democracy, the precondition is that any government is there, that they shall have a majority in the respective legislature. Say for example, you take any state government, that state government to be functional or to be a legitimate government, or the chief minister and the council of ministers to be having a legitimate power, they shall have a majority in their respective legislature. As long as they have the majority in the respective legislature, then that's a constitutional government, and then we can say the administration is carried out in accordance with the provisions of the Constitution. But suppose, let us assume any state government has lost majority. The term of the legislature is there, but the government has lost majority, or there is a no confidence motion against that particular government, then we can come to a conclusion that there is a constitutional breakdown in that particular state. This is not the only way that there can be a constitutional breakdown. There can be other ways of constitutional breakdown also. Say for example, that particular state government is there, which is having majority in the state legislature, but that state government is carrying out anti-secular policies, or the policies of the state government is such that they are doing something in favor of one religion and not in another religion, or they are discriminating between religion, which is going against the secular credentials of our Constitution. Therefore also the president can come to a conclusion that there's a constitutional breakdown in that particular state, because administration is not carried out in accordance with the provisions of the Constitution. Or in other words, let us assume one more example. Suppose let us assume there is a government which is having a majority in a particular state, but that state government is not able to protect what is called as public order in that particular state, because law and order and public order is an item in the state list. To be very specific, law and order is an item in the state list. So it is a responsibility of the state government to ensure a state of peace, security and prosperity in that particular state. If there is a widespread law and order problem in that particular state, which the state administration is not capable of ensuring it, then also the president can come to a conclusion that there is a constitutional breakdown in that particular state. So there are a number of things which the court have interpreted, and by conventional practice certain things are accepted as that there is a constitutional breakdown in that particular state. So why I am discussing this is because we are going back to understand the reason as to why this article 356 was put in the Constitution. So the reason as to why this article 356 is inserted into the Constitution is the members of the Constituent Assembly were very clear. At no point of time they wanted an unconstitutional government to function in a particular state, even though the government got elected by the people, but over a period of time there is a constitutional breakdown. So the moment there is a constitutional breakdown, it won't be legitimate for the government to exist after the constitutional breakdown. So in the meantime, temporarily, till a new government is elected, who will be in charge of the administration of that particular state? The president will be in charge of the administration of that particular state. So that's the reason Article 356 was put in. So what is Article 356? Article 356 allows the president to impose what is called as a president rule in a particular state. Under what circumstances he can impose a president rule? The only condition that is given in the Constitution is what is called as constitutional breakdown. But however, what is constitutional breakdown is nowhere defined in the Constitution. So I have given a list of examples as to what can be considered to be a constitutional breakdown. When the state government loses majority, or in other words, there is a no confidence motion against the government, when the state government engages in anti-secular policies, or there is a large-scale law and order breakdown in that particular state. These are all circumstances where the president can come to a conclusion that there is a constitutional breakdown in that particular state. And whenever there is a constitutional breakdown, then the president can impose what is called as a president rule. So temporarily the state is kept under the control of the president. and till the time the new government is elected. So it is not a permanent thing, it is only a temporary measure. So, and for the president to impose a president rule under Article 356, there are certain procedures that we'll have to understand. So, we'll move forward, we'll try to understand as to what is the procedure, as to how the state emergency is imposed in a particular state. Not just the procedure, what are the consequences, because even in case of the president rule, even in case of the state emergency, when the president rule is imposed in a particular state, the constitution goes for a transformation, as we already discussed. And the transformation is more in line with what is called as an unitary political system. But here, the changes in the governance model is only with regard to that particular state where the president rule is imposed. It does not affect the other states, as in case of the national emergency. So these are the basic understanding, probably you will have to keep it in your mind. So we'll proceed further in trying to understand as to what is the procedure to impose the president rule, what are the consequences, but before that we shall also understand as to what are the guidelines that has been issued by the Supreme Court of India with regard to imposition of the president rule. Because what has happened over a period of time, starting 1950s after the commencement of the constitution, this Article 356 was considered to be misused by the president. Although you'll have to keep it in your mind that it is not the discretionary power of the president to impose president rule in a particular state. Rather, he exercises power based on the aid and advice of the Council of Ministers. So, whenever the ministers, the Prime Minister and the Council of Ministers advise him, he may impose a president rule in a particular state. Otherwise, normally try to understand who is a constitutional head of a particular state. The governor is a constitutional head, and he carries out the administration based on the aid and advice of the Chief Minister and the other Council of Ministers. But when there is a constitutional breakdown, then the Council of Ministers are dismissed in that particular state, and then the administration is directly taken up by the President, which the President can do under Article 356 of the Constitution. And what is the ground on which he can do that? When there is a constitutional breakdown. So this is the basic information you should have. But as you already said, there are a number of cases that has gone to the Supreme Court that this Article 356 is misused for political reasons. Suppose in the center there is one party which is in power, which is not in friendly relations or directly in opposition to another party which is there in the state. So it was alleged that many times this president rule has been misused. So to that extent, the imposition of president rule was challenged in the court number of times. One such interesting case is the S.R. Bommai case. And in the S.R. Bommai case, certain important guidelines has been given by the Supreme Court, which should also be very, very important. You should keep it in your mind. So now let us try to understand as to what are the various guidelines that has been given by the Supreme Court in a case which is called as S.R. Bommai case. Now today S.R. Bommai case has become a leading case. So based on which the courts can validate whether the imposition of president rule is valid or not. So they have to satisfy all these conditions when they impose what is called as a president rule in a particular state. So before I discuss the cases and the guidelines issued by the case, that is the S.R. Bommai case, let us try to have certain factual information about this particular case. So what happened in S.R. Bommai case? Now S.R. Bommai was the Chief Minister of Karnataka way back in 1989. 1989, I think he was from the Janata Party, formed the government after the elections. But after he formed the government, the opposition parties went to the governor and they filed a petition. They made a petition to the governor that Mr. S.R. Bommai is not having majority in the Karnataka Legislative Assembly, because this case pertains to the state of Karnataka. And then subsequently, when S.R. Bommai came to know about these developments, he went to the governor, requested the governor to give him an opportunity. Give me an opportunity that I'll prove the majority, because the petition is not saying the right thing. I will prove the majority if you give me the opportunity. Despite such a request made by Mr. S.R. Bommai, the governor has sent a report to the president under Article 356. So if you read Article 356, you will understand that although the president can impose the president rule under Article 356, the president shall get a report from the governor. But however, please understand, the report of the governor is not mandatory, because what happens by virtue of Article 356 is every 15 days, every fortnight, the governor sends a report to the president apprising the situation in that particular state. So the governor keep updating the president with regard to the constitutional functioning of that particular state. If there's any constitutional breakdown, the governor might immediately apprise the president in this particular regard. So so the governor in the case of Karnataka has sent a report to the president, apprising him that Mr. S.R. Bommai may not have the majority, despite the fact that S.R. Bommai has asked for an opportunity to prove the majority. So the report was sent to the president, and then the president has imposed the president rule in the state of Karnataka. And then subsequently, S.R. Bommai has approached the courts. And he approached the court and he made a petition that the imposition of president rule in the state of Karnataka is unconstitutional because Mr. S.R. Bommai was not given an opportunity to prove the majority. There is an allegation, yes, that people say from the opposition party, I am not having the majority. That is, the chief minister was not having the majority. But however, it was not tested in the floor of the house. It was not voted upon in the Legislative Assembly of Karnataka. So unless and until this is voted upon in the Legislative Assembly of Karnataka, how do you know that I do not have the majority? So merely based on the way that it is perceived by the opposition members, imposing president rule in the state of Karnataka, assuming that the chief minister is not having the majority, is unconstitutional. So therefore, I should be given an opportunity to prove the majority. Otherwise, this imposition of president rule should be declared to be unconstitutional. So this was a petition that was made by S.R. Bommai, which the Supreme Court has found merit in what was sought by Mr. S.R. Bommai, which we will subsequently discuss. So not only this was held by the Supreme Court, that whenever the president rule is imposed in a particular state, that first of all, if it is on the ground that the chief minister is not having the majority or the government is not having the majority, opportunity has to be given to the government to prove the majority. Without giving opportunity to prove the majority, and if the president rule is imposed, then therefore such declaration or such imposition of president rule can be declared to be unconstitutional. So this is what one of the important aspect of this particular judgment in the S.R. Bommai case, but they have issued other guidelines also, majorly to prevent the misuse of Article 356. In fact, why this case is very important? If you look into the discussions in the Constituent Assembly, when this discussion was made by the members of the Constituent Assembly, in fact, Dr. B.R. Ambedkar, who supported the provisions of Article 356, although there are a lot of criticism that Article 356 could be misused in the future, the only reason why this was opposed by Dr. B.R. Ambedkar is that under no circumstances we can allow an unconstitutional government to function in a particular state. That is not acceptable. So temporarily we are placing the state under what is called as a president rule. That's the objective. But however, what has happened, but in his own words, Dr. B.R. Ambedkar said this Article 356 he envisaged to remain as a dead letter in the constitution. Although this provision was there, was designed to be used, but he envisaged and he thought that this letter or this provision shall remain a dead letter. But contrary to his ideas, contrary to his belief, this provision, that is Article 356, which was envisaged to be a dead letter in the constitution, has become a deadly weapon. That's what we understand. So over a period of time, this provision has been misused by government after governments, and lot of state governments has been dismissed unconstitutionally, and therefore in the S.R. Bommai case, the Supreme Court has given a detailed guidelines as to how this Article 356 shall be exercised. What would be the appropriate way of exercising Article 356? So the first and foremost, the Supreme Court made it very clear that the exercise of power under Article 356 by the President of India is subject to judicial review. So what does this mean? That the exercise of power under Article 356 is subject to judicial review. The exercise of power under Article 356 is subject to judicial review, which means that whenever the president rule is imposed, and if the courts come to a conclusion that this Article 356 or the power under Article 356 is misused, then to that extent the Supreme Court can give remedy to the affected states. So they can review whether it has been used properly or not, and if it is inappropriately used or if there is a misuse of power under Article 356, then the affected government can get the remedy. To what extent they can get the remedy, we will also discuss. In fact, the court said that the affected governments can give what is called as complete remedy or full remedy. That means the courts have the power to restore even the state government in that particular state. That is very, very important. That means the kind of remedy that may be given is there may be full remedy that may be given. That's one of the important aspect of the judgment that you have to consider. The courts have the power to restore the state government. That's the fullest remedy that can be given. Suppose if the power under Article 356 is misused and thereby unconstitutional if the president rule is imposed, and if the affected state goes to the court, the court can even reinstate the dismissed government. So that is the fullest remedy. So the use of power under Article 356 is subject to judicial review, and the remedy that can be given is that they can even restore the state government. Now other important guidelines include, whenever a president rule is imposed in a particular state, and what is the ground on which a president rule is imposed, that the state government has lost the majority. That means there is no confidence motion against the government. So if the allegation or the grounds on which the state emergency is imposed is majorly that the state government has lost the majority, then what is the important thing that you'll have to keep in your mind is, the court said that the affected government should be given the chance to prove the majority. Without giving chance to prove the majority, if the president rule is imposed, then it is unconstitutional. So first is they should be given an opportunity to prove majority. And where the majority shall be tested, the only place where the majority shall be tested is only in the legislative assembly of the concerned state, not anywhere else. So the testing of the majority has to happen in the floor of the house. That is basically what is called as floor test. Floor test means to test whether there is majority or not. And where that shall be done, it shall be done only in the assembly and not in any of the other forum. Which means it is not in any of the other places. It cannot happen in the governor's bungalow. It cannot happen in any hotel. It cannot happen in any other avenue. But the only place where the majority is to be tested is only what is called as the Legislative Assembly of Karnataka. So that's a basic understanding you should have. That's another important guideline that has been given. And the next important guideline that has been given by the Supreme Court is, whenever the president rule is imposed, suppose let us assume the president rule is imposed. Once a president rule is imposed, then the president rule has to be approved by both the houses of the parliament. What is the time limit within which the president rule has to be imposed? As per the constitution, once a president rule is imposed, I said that it has to be approved by both the houses of the parliament. That's what is the procedure that is given in the constitution. And what is the time limit that is given in the constitution for the parliament to give the approval is, the parliament has to give the approval within a period of what is called as 2 months. There are 2 months within which both the houses of the parliament has to give the approval. If the parliament does not give the approval, then the emergency, that is the state emergency or the president rule, cannot continue further. So first the president can invoke the president rule in that particular state, provided that there's a constitutional breakdown. And if the constitutional breakdown is because the government has lost the majority, first of all the government should be given an opportunity to prove the majority. Where they shall prove the majority, they shall prove the majority only in the floor of the house, which is where the floor test has to be conducted, not in any of the other places. And if they are not able to prove the majority, then the president rule can be imposed. But this is not the only ground on which the president rule can be imposed. It can be on any grounds where there is a constitutional breakdown. But if the constitutional breakdown is because of no majority, then an opportunity has to be given to prove the majority. But suppose let us assume the state government has failed to maintain law and order, or if the state government has engaged in what is called as anti-secular policies, that can also be considered to be a constitutional breakdown. So in this case, there is no need to prove the majority, because the ground is not that they are not having the majority. They have the majority, but there are other unconstitutional things that is done by the government. So if the president rule is imposed, provided there is an unconstitutional government or there is a constitutional breakdown, then once a president rule is imposed by the president, this has to be approved by both the houses of the parliament. That means they have to accept it by passing a resolution by simple majority. How much time within which they have to pass this? They have to pass it within a period of 2 months. So both the houses of the parliament. So this is what is very important. Now the Supreme Court has made it very clear that once the parliament gives approval, that is both the houses of the parliament gives approval for the imposition of president rule, then only the legislative assembly of that particular state can be dissolved. Till that point of time, the legislative assembly of that particular state has to be kept under a state of what is called as suspended animation. So this is very, very important. It is not mentioned in the constitution, but this is the interpretation that is given by the courts. Now, what do you understand by suspended animation? Suspended animation is a state where the state legislature is suspended in its functioning. That means they actively do not perform any function. They remain completely passive. So they are not active, they remain passive. But however, they have to remain passive. The MLAs would continue to be the MLAs, but without performing any active functions. There won't be any sessions, there won't be any discussions. But how long this can remain in a state of suspended animation? Till the time the parliament gives the approval. The moment the parliament gives the approval, then the legislative assembly will be dissolved, and then there has to be new elections. So what is the reason? What is the reason for this? But the reason for this is, in case if the president rule is imposed, and if the parliament does not give the approval, then the legislative assembly would continue to function. And from the legislative assembly, a new government can be elected. The previous government, anyways, the president rule is imposed, but still the legislative assembly is there. The legislative assembly can elect a new government because the term of the legislative assembly is not yet over. So, in order to avoid a new election, the legislative assembly will be kept under suspended animation. But if the parliament gives approval for the imposition of the president rule, then the legislative assembly will be dissolved, then the new elections will happen, then the new government will be formed. But if the parliament did not give the approval, then the president rule cannot continue further. So the legislative assembly can elect a new government, and a new government can be formed till the time the legislative assembly term is over. So this is the basic understanding you should have. So the Supreme Court has made it very clear that whenever the president rule is imposed in a particular state, within 2 months a parliament has to give the approval. And till the time the legislative assembly has to be kept under a state of suspended animation. That means the legislative assembly would continue to exist, but all the functions are suspended. So that is what you'll have to understand. Once the parliament gives the approval, then the legislative assembly is dissolved. Till the time it will be kept under what is called as suspended animation. So that is the basic understanding you should have. And another important guideline that has been given by the court is that whenever the president rule is imposed in a particular state, and any state government challenges the imposition of the president rule because of the state emergency, a particular state government is dismissed, and hence they are the aggrieved party. So they can go to the court, challenge the imposition of president rule. So in any state where the president rule is imposed, if any state challenges that, then the burden of proof lies in the central government. The state government doesn't have to prove that the center was wrong in imposing the president rule. It is a center's responsibility to prove that they are right in imposing the president rule, that they have got relevant material, or they have the proof of constitutional breakdown in that particular state. So whose responsibility is that? It is a responsibility of the center. That is again a very important thing. And further, the Supreme Court has made it very clear that what is the ground on which the president rule can be imposed is only strictly on the grounds of what is called as constitutional breakdown. The state government cannot be dismissed merely on the grounds that there is what is called as administrative breakdown. That is wrong. So what is the ground the constitution allows to impose what is called as president rule under Article 356 is when there is a constitutional breakdown. So you can ask me, sir, what is the difference between constitutional breakdown and administrative breakdown? So constitutional breakdown means violation of constitution. Say for example, the government has lost the majority, that is no confidence motion against the government, or the government fails to maintain law and order, large scale law and order, not a very temporary or a local. In the entire state there is complete anarchy, suppose, let us assume. Or say let us assume that the state government is engaging in anti-secular policies. So these are all considered to be what is called as constitutional breakdown. But what is an administrative breakdown? Say for example, the policies of the state government is not good. The people are not happy with the governance, there is maladministration, there is corruption in administration. So these are all administrative breakdown, these are all administrative issues. So administrative issues cannot be a ground to impose what is called as a president rule. The president rule can be strictly imposed on the grounds of what is called as constitutional breakdown. That is what the court has said in the SR Bomme case. Now only when all these conditions are satisfied, then only the courts can come to a conclusion, yes, the imposition of president rule is valid. Otherwise, the imposition of president rule can be considered to be unconstitutional. And if it is considered to be unconstitutional, the court has already clarified that they can give full remedy to the affected state. They can even reinstate a government that has been dismissed by invoking what is called as a president rule. So this is very, very important. You should have this basic understanding. All right. So now let us move forward. Let us try to understand as to what is the procedure to impose a president rule. What is the procedure? There is a procedure that is laid down in the constitution if the president rule has to be imposed in a particular state. So what is the procedure? We'll try to understand that as well. So if you look into the procedure to impose a president rule, so first and foremost, who can impose a president rule in a particular state? It is the President of India who can impose a president rule. So it is only the president who has been conferred the power, although not a discretionary power of the president. The Council of Ministers, the Union Council of Ministers might advise the president, so based on which the president can impose what is called as a president rule. And what is the ground on which he can impose a president rule? The ground on which he can impose a president rule is that there is a constitutional breakdown. I'm just repeating this word again and again. And what is constitutional breakdown is not defined in the constitution. So I have given some examples of what can be considered to be constitutional breakdown. It cannot be done merely on the grounds of what is called as administrative breakdown. So try to understand as to what is this constitutional breakdown, right? Now, is it mandatory for the president to wait for the report of the governor? Because under Article 356, the president can impose a president rule, and it is not mandatory for the president to wait for the report of the governor. So the constitution says that the president can impose a president rule in a particular state with or without the report from the governor. The governor may send the report about the constitutional breakdown, but that report from the governor is not mandatory. Even without the report, the president can impose what is called as a president rule. So that's very important. The president, on receipt of the report of the governor or otherwise, this is not mandatory. So that is very important. So under Article 356 of the Constitution, the president can impose a president rule with or without the report from the governor. All right. And whenever the president rule is imposed in a particular state, then that's not a final thing, because I already said it has to be approved by both the houses of the parliament. So what is the time limit within which both the houses of the parliament has to approve it? So they have to approve it within a period of 2 months. And what is the majority with which they have to approve it? They have to approve it with a majority of simple majority. I hope you have an understanding of what is a simple majority. For the proper understanding of majorities, I have already made a separate lecture. So you can watch those lectures, you will understand as to what these majorities are and how these majorities are calculated. All right. So now once it is approved by a simple majority, so how long the president rule can extend? Because the constitution does not allow the president rule to extend indefinitely. There's a limit, or there's a limit to how many years the president rule can be imposed or extended in a particular state is fixed in the constitution. So what is the maximum time limit a state can be kept under the president rule as per the constitution? The maximum time limit is only 3 years. So how long it can be extended? This is the maximum time limit. I'm not saying that once a president rule is imposed in a particular state, automatically it will be there for 3 years. The maximum time limit. But however, you'll have to keep it in your mind that whenever the president rule is imposed, then the parliament gives the approval, then the president rule can extend up to 6 months from the day the president rule has been imposed in that particular state, provided the parliament gives the approval. And can it be extended further? Yes, it can be extended further by another 6 months, again if the parliament gives the approval. In this way, the parliament can give approval 6 times, and maximum the president rule can be extended in a particular state for 3 years, not more than that. Within 3 years, the Election Commission of India has to conduct the election to the Legislative Assembly of that particular state, and the new government has to be formed. Because placing a state under president rule is only a temporary measure. It's not a permanent idea, because temporarily there is a constitutional breakdown in that particular state. To address that constitutional vacuum, the president is taking up the administration. But however, as per the constitutional system, as per the design of the constitution, every state is to be administered by a state government. For that, the government need to be elected. It takes some time for the election commission to conduct the election and for the new government to be formed. In the meantime, the state is kept under what is called as the president rule. That's the idea. So how long? The maximum time 3 years. But once the president rule is imposed and the parliament gives the approval, it can extend up to 6 months from the day the president rule is imposed. Then again the parliament gives the approval, another 6 months. Again the parliament gives the approval, another 6 months. In this way, maximum 3 years. But however, the most important thing that you have to keep in your mind, it is not in all the cases where the president rule is imposed that the president rule can be extended up to 3 years. So normally the idea is, whenever the president rule is imposed in a particular state, the state shall be kept under president rule for 1 year. How long it can be kept under the president rule? It shall be kept under president rule for 1 year. So beyond 1 year, can it be extended up to 3 years? Yes, beyond 1 year, it can be extended up to 3 years. So till 1 year, no issue. So beyond 1 year, can it be extended? Yes, it can be extended up to 3 years, provided these two conditions are satisfied. Only when these two conditions are satisfied, it can be extended beyond a period of 1 year and can be extended up to 3 years. So what are the two conditions? So once a president rule is extended up to 1 year, to extend it further up to 3 years, two conditions has to be satisfied: that there is a national emergency throughout India. The state is under state emergency. Simultaneously, there's a national emergency throughout India or in part of our country where this state is also a part of it. Because the national emergency can be imposed throughout India or it can be in any part of India. But however, this state is also part of the national emergency and there is also state emergency in this particular state. On account of the national emergency, the Election Commission of India is certifying presently it is difficult to conduct the election. When these two conditions are satisfied, try to understand that already this state is in the state emergency. On top of that, there is a national emergency throughout India or in any part of India where this state is also covered. And because of the national emergency, the Election Commission of India is telling the union government that presently it is very difficult to conduct the election in this particular state. Therefore, the state emergency can be extended. So on these two conditions, if they are satisfied, then the president rule can be imposed for another 6 months, another 6 months, another 6 months, another 6 months. But how long it can be extended? It can be extended up to a maximum of 3 years. So that's a basic understanding you should have. So normally whenever the president rule is imposed, so normally it is for a period of 1 year. And by the parliament giving the approval, it can be extended by another 6 months. So normally 1 year. So beyond 1 year, can it be extended? Yes. How long it can be extended? Up to 3 years. Under what two conditions? That the particular state is also covered under the national emergency. On account of the national emergency, the Election Commission of India is certifying presently it is difficult for them to carry out elections or conduct elections in the present state where the president rule is there. When these two conditions are satisfied, then the parliament can give the approval subsequently and then they can extend the president rule up to a maximum of 3 years. But however, within 3 years, the Election Commission of India has to conduct the election and the new government has to be formed. So this is the basic understanding you should have. So if the question comes, how long the state emergency can be extended or imposed in a particular state, the maximum is 3 years, but subject to these conditions. But otherwise, it is normally 1 year. And the state emergency can be revoked at any point of time. So who can revoke the state emergency or the president rule? The president can revoke it at any point of time, again based on the aid and advice of the Council of Ministers. So this is the basic understanding you should have with regard to what is called as a state emergency. So basically, who can impose a state emergency? The president can impose a state emergency either based on the report of the governor or otherwise, but by the aid and advice of the Council of Ministers, when he believes that there is a constitutional breakdown in that particular state, only on the grounds of constitutional breakdown. Once the state emergency is imposed, it shall be approved by both the houses of the parliament within a period of 2 months. Once approved, it can extend up to 6 months from the date of proclamation of from the date of the president imposing what is called as a state emergency. Again, it can be extended by another 6 months if the parliament gives approval by simple majority. In this way, maximum they can extend up to 3 years, provided beyond 1 year up to 3 years, that there is also a national emergency throughout India or national emergency which is covering this particular state. And also the Election Commission of India certifying that it is difficult to carry out elections presently. So these are the two conditions that has to satisfy. And then at any point of time, the president can revoke what is called as the state emergency. So this is the procedure that you have to keep in your mind. But again, before I complete this particular lecture, one more thing that you have to keep in your mind is what is the consequence in case of putting a state under what is called as a president rule. There are two important consequences that you will have to keep in your mind. So the first is with regard to what is called as the executive relationship between the center and the state. What does it mean by executive relationship? To what extent the union government may have control over the state government when a president rule is imposed in a particular state. In fact, if you talk of the executive relationship, I would say that all the executive powers are taken up by the union, because the state is kept under what is called as a president rule and there is no state executives. In fact, the chief minister and the council of ministers in the state are dismissed. And because they are dismissed, So who will carry out the entire state administration? Because now it is called as president rule. The entire administration is taken up by the president. While the president can delegate the power to the governor, that's a different thing. But the governor does not act on the aid and advice of the Council of Ministers, CM and the Council of Ministers, but rather it is the president who may direct the governor. So there is no state executives in the first place. So when you talk of the executive relationship, all the executive authority is taken up by the President of India. So this is very, very important. Now the second important consequence is with regard to what is called as the legislative relationship. Is there any way the legislative relationship changes? Yes. The legislative relationship will also change, because what happened whenever a state is kept under the president rule, the state legislature is dissolved. This is very, very important. So what will happen to the state legislature? The state legislature will be dissolved, but it will not be dissolved immediately, because the Supreme Court has already said that the state legislature has to be kept under what is called as suspended animation. So how long it will be kept under suspended animation? It will be kept under suspended animation for a maximum of 2 months. But whenever the parliament gives the approval, then the state legislature will be dissolved. So if the parliament gives the approval within 1 month, then the state legislative assembly will be dissolved immediately. So this is the basic understanding you should have. That means to what extent the legislative assembly or the legislative relationship changes. The moment the parliament gives the approval for the imposition of president rule, the legislative assembly of that particular state is dissolved, and hence there is no state legislature. And when there is no state legislature, who will make laws for that particular state? So in the meantime, when the state is kept under the president rule, it is a parliament which will make the law for that particular state. So who will take up the legislative authority, or who will make the laws for that particular state? It is a parliament which will make that particular law, and further the parliament can delegate this authority to make law to any of the other authorities as well. That means naturally the power will come to the parliament, but in turn the parliament can give this authority to anybody else, including the president of India. But normally this power is exercised by the parliament. So two important things that you have to understand. So the executive authority will be taken up by the president, and the legislative power will be taken up by the parliament. So try to keep both the things in your mind in case of the consequences when it comes to president rule. So while the executive authority is taken up by the union executive, that is a president, while the legislative power is taken up by the union legislature, that is a parliament. So to that extent also, the constitution becomes unitary in character, because the state authority is completely deprived in relation to this particular state where the president rule is imposed. So these are the two important consequences of the president rule as well. So with that, we are almost coming to the end of the discussion. So what you have discussed, I'll just take a couple of minutes. First, we have understood the provision of Article 356. We also understood as to what is the procedure as to how the president rule is imposed in a particular state. And most importantly, we also understood the guidelines that has been given by the Supreme Court of India in the S.R. Bommai case, where the Supreme Court has categorically given a detailed guidelines, and they also categorically said that if any state government is involved in doing anti-secular policies that goes against the provisions of the constitution, and that can also be seen as what is called as the constitutional breakdown, and that's a valid ground for imposing what is called as a president rule, along with the other criteria that is laid down in the constitution. And then most importantly, the Supreme Court has also categorically said that full remedy can be given to the affected state. So these are all some of the important things that you'll have to keep in your mind. And we also understood the consequences, basically the legislative consequence and the executive consequence when the president rule is imposed in a particular state. And with that, we are coming to the end of the discussion. So before that, I wanted you to solve this particular question. And before you solve this particular question, let me put across a question. If any of the students know how many times the president rule has been imposed in India after the constitution come into force, how many times do you think Article 356 has been invoked? And which are the states in India till this point of time where the president rule has not been imposed? If you know the answer, you can put it in the comment box. These are the comments which is going to really motivate me, because I do understand that the students are following these lectures. Okay, so try to put the answers in the comment box. If you have any suggestions and if you have any queries, try to reach out to me. Think me as your friend or a mentor who can help you out in your process, and do not hesitate to reach out to me. All right. So look into the question. If the President of India exercises power as provided under Article 356 of the Constitution in respect of a particular state, then A, the assembly of the state is automatically dissolved. B, The powers of the legislature of the state shall be exercisable by or under the authority of the parliament. Article 19 is suspended in the state. The president can make laws relating to that particular state. So try to answer this particular question. That means basically the question is, what is a consequence in case of the president rule? So we have seen two consequences, legislative and executive consequences. So based on that, this question can be easily answered. All right. So with that, we are coming to the end of lecture number 63. So it will take me at least another couple of months, before which I'll comprehensively try to cover the entire subject Indian polity, and then subsequently we'll move on to the other subjects. So trying to help out maximum number of students. So if you have any queries, I'm saying, please do reach out to me. Do not hesitate. And if you like this video, please share it to your friends, family members, or the others also who are preparing for the UPSC examination or other competitive examination. And I'm quite sure, and I have 100% conviction that it is going to be extremely useful to the students preparing for the examination. Thank you very much for watching this lecture. All the best.